Take two of TalkLex. Welcome back. I'm Scott Peterson. We tried this once; it didn't go well. We are moving into video recording of our podcasts here. You missed
the first time anyone's ever done this.
Yeah, it's clearly never been done before. I took the good light to the office, and Giovanna's upset with me. But as I explained,
started off on the wrong foot.
We start off on the wrong foot. As I explained in the prior version of this, I think I need the light more than she does. I'll let the listeners and watchers be the judge of that. So we're talking this week about a bunch of things, but in light of the fact that Veterans Day is tomorrow, we're going to talk a little bit about some of the rights that military veterans have in the workplace. And Giovanna being the knowledge base when it comes to that, and the person who handles most of the litigation for those types of cases in our firm, why don't you kind of walk us through what protections active duty and otherwise military veterans and military service members have in the workplace?
So typically the two categories of employment issues that you see with veterans are either re-employment after active duty or disability discrimination. So the first category is addressed by USERRA, which is the Uniformed Services Employment and Reemployment Rights Act. And that's what requires an employer to hold your job for you while you're on active duty. And that includes training. So that includes reservists, members of the National Guard. When you have to leave the workplace to serve your country, your job has to hold your place for you. And we sometimes see issues with that, not always in terms of the reemployment, but what happens when you're back there? Are they taking your service into consideration in making promotion decisions? And that's where a lot of the case law is. And that's a case that we recently handled. We'll talk about some of the disability context cases that we've handled, but probably our most recent USERRA case was a promotion case. So he went out on active duty multiple times during the course of his employment. And the issue in the case was, before he joined the military, he had no problems with being promoted. After he joined the military, his position in this company sort of stagnated for a pretty long time. And that was the basis for the claim. There were multiple opportunities over his employment for him to be promoted. And our argument was, and there was evidence to support this, that they were taking his military absences into consideration in making those decisions. And USERRA says you can't do that. Just like you can't take somebody's pregnancy into consideration when you make those decisions, just like you can't take every other protected status into consideration as what we call a negative factor in employment decisions, you can't take someone's absence from work for military service as a negative point against them in making promotion decisions. So that's what that case was about. And what's interesting about USERRA, I think it's probably the only employment statute that's like this. It has no statute of limitations. So you can go back as far as you want and make a USERRA claim. So this case happened to be very labor intensive because these issues went on over a span of 10 years. Under pretty much any other employment statute, you are not going to be able to go back 10 years and try to recoup, lost wages or something like that. There's arguments that you could make that, at the very least, you can show that things that happen outside of your statute of limitations are relevant, but almost all employment statutes have a really short window to either sue or go to an agency to make a complaint. And USERRA does not have that.
Yeah, the point about the agency complaints is a big one. Under many federal employment statutes, you have to file a claim with the EEOC that's the Equal Employment Opportunity Commission, within 300 days of the claim, or you lose the right to file that federal claim. And that's tight, that window, let alone, potential cases that involve notice of claim requirements, which are significantly shorter, which I know you is a bane of your existence. But so in the USERA context, does it protect unlimited military leave? Is there a certain amount of time that's protected? How does that work?
You're allowed to take a cumulative 5 years off to be protected by the statute. So it's not completely unlimited, but it's a pretty significant period of time. And just going back to the EEOC charges, we'll talk about this a little bit later, but a lot of USERA cases are disability cases also. So if you have a claim under the Americans with Disabilities Act, you do need to file an EEOC charge, and they're only going to look back a certain period of time. So if you are representing a military veteran or service member and a disability is involved, you need to keep that in mind. You don't want to just hang your hat on USERA and say, I have all the time in the world to do something.
So in addition to claims under USERA, you mentioned disability discrimination claims. How does that typically come up in the context of veterans or service members? Where do you usually see that happening?
Well, there's some cases that go either way as to whether there's the concept of disability discrimination under USERA. I think at this point, under the law, when we've looked at it, I would say that disability discrimination is not really part of USERA. It can be a little confusing because USERA does require reasonable accommodations for injuries, service-related injuries, but I think the context of that is more, I'm out of work, you're holding my job for me, I'm coming back to work, but now that I'm coming back to work, I'm injured. Then they have to accommodate you, and they, even to the point of maybe putting you in a different position. But that's not quite the same as disability discrimination. So a lot of times I would say probably a pretty common context in the military realm would be PTSD. So I think it's kind of generally known that employers are not as great with mental health disabilities as they are with a physical disability that they can see and understand. The case law and the EEOC is pretty clear that lots of different mental illness is a quote unquote disability within the meaning of the law. PTSD, I would say, definitely is, especially if you're being treated for it. So we see that, and we've handled some cases where PTSD was the disability, and it was service related, but that doesn't necessarily mean it's a USERA case. So say you were in the military years and years and years ago, something traumatic happened to you there, you've been honorably discharged, now it's like 10 years later and you're still dealing with the effects of this. That's not the same as being reemployed. Now you just are a civilian who has a disability that happens to be related to your military service. So I would typically consider that to be an ADA, or in New York, a human rights law case, as opposed to a USERA case.
ADA being the Americans with Disabilities Act. And we've had a number of cases that involved service veterans with PTSD, as you said, several years later. And they've had, various ailments related to the PTSD, including, severe anxiety and depression and things that impaired their ability to work and ultimately led to problems in the workplace or termination. So would you say that that's more common across, the spectrum than the sort of cut and dry USERA type claim?
Yeah, there's not tons of USERA cases out there. There are a lot of disability cases out there. I think, one thing that we see in the PTSD context is you sort of mentioned issues that may interfere with your work. Yes, we've seen that where people need to, and by interfere with our work, we don't necessarily mean you can't do your job or you're bad at your job. We might mean like you need to take some time off, you need to get medical treatment. We've had clients who've needed to go to rehab for alcohol or drugs. Those are all things that quote unquote interfere with your work, and the law does protect some types of medical leave. But one thing we also see with PTSD is not even anything that's actually interfering with your work. You may be being treated, but you don't need to take a leave of absence. You're doing just fine at work, but there's a stigma attached to that. So we've seen people that were perceived really totally unfoundedly to be violent, to be sort of a threat in the workplace just because they are a military veteran with PTSD. So the law protects that, this perception of either a perception of having a disability in the first place, or that your disability is, somehow negative in the workplace. So that's something that I think can be unique to service members, this stigma to PTSD that we've definitely seen come up. And a lot of military veterans are in law enforcement, so you can see that happening where you carry a firearm, somebody gets wind of your PTSD, maybe now we've seen people get their firearms confiscated for no reason. So that's unique, I think, in that context.
Yeah, I'm thinking of a couple of cases specifically that involved, kind of rumors and accusations that were completely untrue related to somebody's PTSD. And it's sad. It's sad to see it because the people in those cases didn't have there was no reason for them to be targeted the way they were. Now, going back to what you said before, though, if somebody is suffering from, PTSD and related symptoms at work, maybe we could talk a little bit about what the obligation on the employer is, to have a conversation with the employee to see if there's something they can do to accommodate them.
Yeah, if you need an accommodation, like some time off, there's a few different laws that could apply to you. The FMLA, the Family and Medical Leave Act, applies to taking time off to treat what we call a serious health condition. That doesn't necessarily equal a disability, but often FMLA and disability cases kind of go hand in hand. The disability laws like the ADA and the New York State Human Rights Law also have room in them to protect a medical leave for a disability. So let's say you're not covered by FMLA because you work for a private employer that's small. FMLA applies to 50 or more employees. You might be covered under the ADA or the state law for a medical leave. And actually, I would say in our practice, when employers make mistakes, it's most commonly in that context. They just don't think about a medical leave as being protected under the disability laws. If you're not covered by FMLA, a lot of employers, I think, don't even consider the fact that the disability laws might kick in at that point.
Well, and I'm also thinking of in the context of if you've got an actual disability, the requirement that the employer engage in what's known as the interactive process. And so sometimes you see employers who kind of write things off and make, spontaneous decisions that, sorry, we can't help you, without actually having the conversation and talking with the employee about, what is it that you need and what is it that we can do, and would this or would this not present, a burden for us to accommodate you.
Right.
All right. Well, I mean, I think that pretty much covers the majority of the workplace rights for service veterans and active duty. And is there anything else you want to cover before we kind of move on?
Yeah, just one thing that kind of came to mind is when we were talking about, USERA or PTSD and the different reasons why we might see a service member or veteran being discriminated in the workplace. One thing that we've also seen is if you sustained a disability in the line of duty, including PTSD, you are probably entitled to veterans benefits. I think we sort of see this in a lot of different contexts where some people can be hostile towards people who are receiving a financial benefit from the government. They just don't like that. It happens in many different contexts, and veterans benefits are not, unique in that. So we have seen employers who get wind of the fact that somebody is receiving a relatively significant veterans benefit, And they either don't like that, or they think that that means that you can't actually work. And I think it's something that's important to keep in mind, that that's not true. So VA benefits are not only meant to compensate you in the sense of your medical treatment that you may need, but sort of built into that is this idea that you're being compensated because of the fact that you were injured while serving your country. So you can have an almost 100% VA disability rating. That does not actually mean you are disabled from working. In fact, the law wants you to work. So I think that's just something to keep in mind. I don't think people really think about that very much, but it's definitely something that, I've seen that come up more than once, actually.
Yeah, it's familiar. I've certainly seen it come up as well. The general proposition is that the law wants you to work. Would you say that's fair to say in employment cases? If you can get a job, the law wants you to try to get one?
Yes, the whole employment law system is designed to keep people employed, which makes sense.
Yeah. All right. We've got a couple of contenders for the misleading headline of the week this week. First, we'll talk about Twitter. As probably everyone knows at this point, Elon Musk came in and purchased Twitter, and in typical Elon Musk fashion, made some very quick and very scandalous. That's not the right word. very.
Well,
What's that?
I said controversial. I don't even know if it's controversial. Like,
yeah, sort of controversial decisions, depending on where you sit, I suppose. He's apparently trying to clean up the bot problem at Twitter. I don't know enough about the bots at Twitter to know. I'm not particularly active on Twitter. I think it's a good place to get news, but it also seems to be a cesspool of anger, like much of social media. But that's kind of beside the point. The point, as it relates to the misleading headline, relates to his decision to lay off 50% of the Twitter workforce last week. Where is the misleading headline come in that?
so after that happened, you started to see a lot of headlines that either he violated the labor laws when he did that he was being sued for violating the labor laws when he did that. And obviously a headline does not give, very much context, but there are legal protections on the federal and state level for mass layoffs. So for certain types of layoffs, you do need to give some notice before that happens. So I think those headlines were a little bit misleading, talking about these lawsuits. They implied that he really did sort of violate the law when he did this. But if you kind of look a little bit deeper, some of the lawsuits, the attorneys acknowledged that they were preemptive, and that and then after the fact that he was kind of working to comply with these laws. I also read that the laid off employees are actually being paid their full salary and benefits through the beginning of next year. So, that's not necessarily our area in practice. It might be a no harm, no foul situation ultimately, but definitely something that was in the news a lot at the time, that might not have been sort of as straightforward as it seemed.
Yeah, I'm sure there are lawyers, clearly there were lawyers lined up to file lawsuits against Twitter and Elon Musk the first opportunity they had. And when you say preemptive, that's interesting. So did they actually file? They didn't file the suits before the layoff. Would they file them as soon as the layoffs happened?
Yeah, I'm not sure. I mean, most of the time you can't file a lawsuit preemptively. That's the whole point. We have this whole concept, it's called being quote unquote ripe. So you have to actually wait for something bad to happen and for you to have some damages before you sue. So they might have filed them, had them ready like the second they got laid off. But yeah, it's very interesting. I'm not on Twitter. I've never been on there. I don't know what's going on over there, but I have taken some pleasure and humor in some of the other social media, just like parodying whatever is happening over there.
Well, I actually was chuckling today to myself when I read that one of his first emails to the remaining Twitter staff was that he expected them to be back in the office for 40 hours a week. And there's apparently a huge uproar about this.
Yeah, I would imagine that like in the tech realm, people are not excited about being in the office. And that's a whole other thing that we've talked about during COVID many times. Can your employer force you to come back to work? Probably, yes, they can.
Yeah.
But he did that at Tesla too, didn't he? Weren't his Tesla employees upset about that?
Tesla and SpaceX apparently requires employees to be in the office for 40 hours a week. Now, I think, most of us who came up, in the 90s and early 2000s, particularly in the legal profession, there was no sort of discussion about whether you're going to be in the office 40 hours a week. You were in the office 40 hours a week until you earned the ability to not be in the office 40 hours a week. I don't want to sound like some old curmudgeon. I totally appreciate the idea of working remotely, as Giovanna can attest at the moment.
I was going to say, as your hoodie sweatshirt, my
it's a sweater, but thank you for pointing it out. So, in any event, all this does not seem particularly well in the Twitterverse, but just to kind of touch on one thing you mentioned, the idea of filing before the action happens, you have to have what's called standing in order to even file a lawsuit, which means you have to have been aggrieved by the action. So theoretically, if there was not a layoff made, you would have no grievance that would give you standing to file the lawsuit. So I think it's interesting how quickly they were filed. But again, that's kind of a misleading headline. Leading us to the other contender for this week, and it's a tough one. I read an article or several articles about a lawsuit arising out of the Jeffrey Epstein situation, where one of the accusers, who was the subject of at least one of the documentaries that I watched about it, had brought a lawsuit against the attorney Alan Dershowitz, who is no stranger to scandal and vitriol among the media and sometimes the legal community. Dershowitz, you may remember, represented Epstein at least for a while, and was apparently connected to him in some fashion during the course of his life. Long story short, one of the Epstein victims filed a lawsuit in which there were allegations made against Dershowitz that they had unconsensual, non-consensual sexual activity. Dershowitz denied it, essentially called her a liar, said she was making it up. She sued him for defamation, and just this week, that case was discontinued. The misleading part of this is that at least one of the articles I read said that the case was settled, which would lead the reader to the conclusion that there was something exchanged for the discontinuance or the release. I'm not going to get into the specifics of this. Epstein obviously was a horrible human being. The whole case is disgusting. And when you look at some of the things that happened leading up to the case, or leading up to all of the stuff being brought out into the light, it becomes clear that there were some very unfortunate deals negotiated in part by Dershowitz on behalf of Epstein going back several years that allowed him to continue doing what he did for a long time. So there were some serious problems. But the headline read that this case settled. And when you looked at the article, it turns out that the accuser discontinued the case. And strangely, in my opinion, actually came out and says that she thinks she may have made a mistake in accusing Dershowitz of this non-consensual sexual relationship. So I don't know about you, but that's very unusual in our world. Typically, if a case gets resolved and there is a settlement, the parties, there's an exchange of money, the case is discontinued, and it's over. There are occasionally times when a case gets discontinued because either the client doesn't want to move forward, or there's a discussion among the parties and it's determined that it's the best course to just discontinue the case without an exchange of money, or there's an assessment made that, after everything is shaken out, the case just doesn't have the merit that you thought it did. In those cases, if you were to discontinue a case, I can't imagine a scenario where we would have a client come out and say, I think I made a mistake. I don't know if that was part of some agreement between them that would, allow them all to move on. But I thought it was interesting.
So this article said there was no exchange of money at all, because I agree, I would not be able to wrap my mind around making a statement about that if there was no either financial settlement, or, I mean, I don't know, this is like totally speculating. He might, I mean, like a threat of litigation against you. I really don't know.
Yeah,
But I mean, I think in general, when you have a headline that says so-and-so settled a case, it implies that that person paid money to settle the case.
yeah, here they actually went to the length of issuing a joint statement where they specifically said that the resolution of the lawsuit did not involve the payment of money or anything else. Look, Dershowitz is obviously a very powerful guy. I don't know what was going on in that litigation. The plaintiff in the case came out and made the statement that she recognizes how stressful this has become for her, and for her and her family, and that it was time to bring an end to it. It's really interesting. It's highly unusual. Nothing about that case is really normal, I suppose. And you feel for her and for all the other victims. But it's, again, another example of headlines not necessarily reflecting accurate stories of what happened. And more than one of the articles I read referred over and over again to the fact that it was a settlement. But a settlement typically does involve exchange of something. So, any other comments on that one?
No.
Shaking your head, no. Okay. Anything else? What else do we want to talk about? Is there anything else?
Well, we were going to, we have a little sort of teaser for our next podcast, which is going to be with Kevin O'Brien, a criminal defense attorney that we've had on in the past. And one of the things that he's going to talk to us about is bail reform in New York. And he's going to educate us about that because that's not our area. But one of the reasons why we thought that would be helpful was kind of, I wouldn't necessarily call this a misleading headline, but I think, periodically when you make the mistake of reading the comment section of an article, it just sort of reinforces the fact that, unfortunately on the internet and on social media, you really have to expend a lot of mental energy to sift out kind of misinformation and comments that are just completely made without apparently having actually read the article. And yesterday there was an article in one of our local newspapers about something that I think is every parent's worst nightmare, which was 2 little girls being kidnapped out of their home in the middle of the night by some disgusting human being that they met on a social media app. And if you read the article, the headline didn't say anything misleading. And if you read the article specifically said that the person was sent to jail without bail. Every single comment in the comment section was, thanks to, insert liberal, or Democrat governor or whoever, so-and-so is back on the street. That was just a factually incorrect statement. And we see that a lot now that we have some bail reform legislation in New York, where there has been this idea perpetuated that due to this, we have a lot of like dangerous, disgusting criminals roaming the streets. I honestly don't know if that's true or not. I don't think it is to that extreme. It certainly was not true in this particular situation. And I've seen that multiple times, bail reform sort of being used as an excuse for crime without any sort of correlation between the two things. And in this particular situation, this person was denied bail, so it was like completely irrelevant. But that sort of made us want to have somebody come on and explain this to us a little bit more, because I think, with the elections that just happened, I think we recognize that this idea of a lot of sort of crime is out there in sort of like the public discourse. And I would like to hear from somebody who actually practices in that realm as to whether this is all true or not, or what his take on that is.
Yeah, Kevin will be our first repeat guest on the podcast. And I love talking to him. He's a very smart guy. He's also one of the straightest shooters you'll meet. He'll tell you exactly what he thinks, which I appreciate. And so we look forward to having him on. We're going to talk bail reform. We're going to talk about the newer rules over the last couple of years relating to disclosure of evidence by prosecutors. And, criminal law affects, next to employment law which is part of what we do, and, injury cases, which affect tons of people. Criminal law affects lots of people too. And it's important to know, kind of get an idea of what the reality is out there versus what you just hear from people who read headlines and just talk on social media about things that they're not really familiar with necessarily. So, all right. Anything else before we wrap?
Nope.
Next week, I'll give you the light, and we can be even on that. So, all right. Thanks for listening. If you want some headphones too.
Cool
thanks for listening. If you're enjoying the show, please subscribe. Follow us on Instagram. Leave us a favorable review on iTunes or wherever your platform of choice is. And thanks again for listening, and we'll talk to you next time.